You will just be kind enough to have para 15 of the symbols order. Statute compilation PDF.
Para 15 of?
Sorry?
15 of para 15?
Symbols order.
Symbols order.
This is in the context of the same issue, right?
Yes,
Issue F.
same. We were at F, and also in the light of the question that my lords posed to me before lunch of split under 10 schedule vis-a-vis rival faction. I just needed to answer that, so I just need to show two provisions to your lordships. Para 15,
Where is that symbol order?
PDF 103, statute compilation.
1. Statute compilation 1.
103, yeah.
Yes.
Yes.
With your lordship's permission. Power of the commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one of the such rival section or group or none of such rival section group is that recognized political party, and the decision of the commission shall be binding on all such rival sections or groups. Now kindly compare this, my lords, with para 3 of the 10th schedule as it existed. PDF page 50 of the same compilation.
What page is this?
PDF page 50.
PDF page 50, my lords.
50.
This is something else.
Yes.
Yes.
Just as SMA as that? Yes, that's. Disqualification on ground of defection not to apply in case of split, where a member of a house makes claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party. And now please have B. From the time of such split, such faction shall be deemed to be the political party to which he belongs for purposes of subparagraph 1 of paragraph 2, and to be his original political party for the purposes of this paragraph. So when you split and form a group, that becomes your original political party within 2(1)(b) and saves you from disqualification under 2(1)(b). Whereas under para 15 of the symbols order, within the party itself, a rival faction emerges, goes to the election commission and says, I am the recognized political party. And as your lordships have held, there can't be two recognized political parties within the setup. The symbol can't be split, the name can't be split. So either none of them get it or one of them emerges as the recognized political party within para 15 of the symbols order. Whereas here, after a 1/3 split, it calls itself. It's like saying if Eknath Shinde or Uddhav Thackeray, one of them had split and called themselves the Shivsena Thackeray, the other would have called themselves the Shivsena Shinde. The 1/3 split would have become the new original party. That's not our case. We've never claimed that we have a new original political party. Our political party remains the same.
This, as the first part of the section, a member of the House makes a claim that he or any other member of his legislative party constitute the group representing a faction which has arisen as a result of a split
In his
which is prior in point.
Right.
So what is the as a result of the split, in his original party.
Right.
Therefore, that must occur prior in point of time.
Right.
In the political party, there must be a split, the consequence of which will be recognized in the legislature.
Right, right. And you will call yourself the new original political party for purposes of 2(1)(b). Now, my lords, in terms of the question that I was addressing your lordships on, which was F, what is the impact of the removal of paragraph 3 of the 10th schedule? My respectful submission, my lords, is that a defense which was available is gone, is no longer available to disqualification under the 10th schedule. Only merger as a defense now remains. B, it doesn't concern me at all because my case has never been, or never have I sought the, nor can I seek the protection, but it's not in the constitution as a protective clause, nor has this ever been my case. My case is that I, as the faction within the party, represent the recognized political party. And my lords, when I come to the judgments, I'll show to your lordships that this issue, when it arose, and this in itself can never be a 2(1)(a) case either. Merely because a faction says that I'm the recognized political party and goes to the EC for a relief under para 15 of the symbols order doesn't mean he incurs disqualification under 2(1)(a) by saying that I've lost the majority. Because in Yadurappa, this was the exact case which arose. MLAs there went and said, we do not have faith in Mr. Yadurappa. And ultimately, the speaker disqualified them. The Supreme Court said that they have only said we do not have faith in Mr. Yadurappa. They have not said that they don't have faith in the political party or they formed another political party. And such the drastic step taken by the speaker to disqualify them under 2(1)(a) was far beyond what the facts necessitated in the facts of that case. So to say that merely because I go to the governor and I say that here today, given the ideology of the party, the overwhelming cadres don't want to go along with the MVA. Our entire contention has not been that the Shivsena should not form the government. At that stage, our contention wasn't even that the chief minister could not have formed the government with any other political party. Our lack of faith in the ministry was because you were carrying on with a party whose ideology did not match our ideology. We had been in loggerheads for very long. And going along with them was creating a huge discord and discontent amongst the cadres and party workers. Now, can this be treated? By this logic, my lords, any form of internal dissent, anyone raises any voice of dissent, which is the essence of democracy within a political party, would be said that he's incurred the wrath under 2(1)(a). And I'll show cases of 2(1)(a), what overt acts have been done in those cases. You go with another rival faction, you go there and say, I'm helping them form the government. I don't have any longer any faith in the political party that I belong to, which is ruling. Those are the kind of overt acts which are 2(1)(a) cases. Here, the only allegation against me at that stage was, you have not attended 2 meetings. In fact, at that stage, the allegation was only that you have not attended the 2 meetings which have been called on 21st and 22nd, and thus you have voluntarily given up the membership of the party, the first disqualification petition and the second disqualification petition, as on 2nd of July 2022. And then came the issue of whip, by when both factions had appointed their whips, leaders, all that dispute arose. That's a separate 2(1)(b) issue. So according to us, my lords, as far as paragraph 3 of the 10th schedule is concerned, A, had it been on the statute book, still, it's not something that I would have relied on. Because according to me, I am the majority, I constitute the recognized political party, and today I have an order also, which is the subject matter of another petition. But my whole case was that under the 15 of the symbols order, I am the faction which represents and ought to be recognized as the original political party. That was my case.
So what does the speaker do in such situations where you raise a claim that you are the political party?
Well, the speaker is only concerned as far as involuntary membership is concerned. According to me, Malas, this does not constitute an act.
Involuntary.
Which,
We are
on
in this
2(1)(b),
case,
2(1)(b),
where under 10th schedule violation, they say that there is a violation of the 10th schedule and you take the plea that it is not a case of a split, but it's a case of reorganization or realignment of the party, and I have the majority of the party. What is the speaker supposed to do there?
Yes.
What is the inference that he is supposed to draw?
So-
will he say that it is not a 10 schedule case?
My lords, what he will say in such a case is, and that has been our case, that his link is with the whip and the leader of the legislature party. That is why I read out those rules of the Maharashtra Legislative Assembly to your lordships, that the members elect a leader. The leader in turn informs the speaker of all the designated posts, the people who will hold various posts. And even when the 10th schedule existed, in Rana's judgment, the Supreme Court said the speaker cannot embark on an independent inquiry to find out whether there has been a split within the political party at all. Even the prima facie view that he forms, even when 3 was there, was only on the question of prima facie there's been a split. Today, the split is an inconsequential issue because para 3 is not there. Today, the question is of a rival faction and under 2(1)(b, not obeying the orders as communicated through the whip. Now, not communicated by the whip is the issue of which whip do you follow. Now, if the majority of the members of the legislature party with the political authority of the political party appoint a leader and appoint a whip, naturally the speaker will be in touch with that whip.
Your answer is that speaker has no option except to go by the majority of the legislature.
Rule of majority as far as the legislature party for
The context of a 10 schedule.
in the context of 10 schedule.
Only majority.
Majority, but the mistake which is being sought to be made is to segregate a legislature party and a political party. That legislature party necessarily carries with it the political authority of a political party. And that is where, my lords, para 6A and 6B of the symbols order becomes important, because 6A and 6B of the symbols order both say that for the continued recognition of a political party, the vote percentage, the MLAs, the MPs are all essential for even a political party to survive and continue. So this distinction which is being drawn to say that you've only brought about something in the legislature party and you don't have the support in the political party is wrong. And the speaker's inquiry is limited in such a case. If the speaker could do the same thing which the election commission could do, then all those lines, my lords, where your lordships said even when para 3 existed, will not embark on an independent inquiry, will only take a prima facie view, whether 1/3 is split or not, because the speaker does not have the wherewithal, my lords, it's the election commission.
In other words, to simplify it, sorry for asking you repeatedly the question. Leave aside their argument of drawing a distinction between political party and a legislative party, leave that aside. As you are arguing, the only method that the speaker can adopt in a case where somebody sets up a case of he garnering the entirety of the party is to just go by the number of legislators that he has, that group, that's all.
And be in touch with the whip and the leader of the legislature party as to what are the
Again,
instructions.
there is a problem because there are 2 whips.
Sorry, my lord.
There will be 2 whips.
Right.
So in the teeth of 2 whips, the decision that he has to take is a majority decision.
Because, my lords, your lordships are absolutely right, because the rules say the members of the legislative assembly will appoint the leader. If the majority of the members of the legislative assembly appoint the leader, and that leader in turn is in touch with the speaker and communicates all the decisions to him, they are presuming that what is done there does not have the support of the political party. But there is no basis to say so, because they make the mistake of saying that the 2 are separate. And because the 2 are separate, you have done all that you had to do within the legislature party, but you did not have the support in the political party. What is actually proved is quite to the contrary, because today it is shown even by the competent constitutional body, which is the Election Commission of India, that I am the political party. The speaker's interaction, my lords, is with the whip, with the leader. What are the directions given? He will not embark in to find out what has been the political division in the political party. For that, under 15, otherwise, my lords, if that all could be done under 15A, under 15, the power for determining this very question has been given to the Election Commission, and your lordships have said is the exclusive jurisdiction. And the reason is because when that is done, talukas, districts, MLAs, MPs, percentage of votes, constitution, on the date when disputes arose between parties, what was the stated position of various factions, everything is taken into account. Then, my lords,
does para 15 of the symbols order also necessarily implicate a split within the meaning of para 3 of the erstwhile provision of the 10th schedule or no?
no, my lords, no.
What does a splinter group mean in the symbols order? Vis-a-vis the split in 3, which is now being
Because
committed.
there are two rival factions
Within a
the
political party.
Yes.
who emerge, and both claim that we are entitled to be the recognized political party. So one of the two, who it is accepted, carries on with the party and the symbol. Then,
So, Mr. Kaul, since that order, just to understand, 15, once it applies and you say the EC's decided it, that's also perspective, right? It obviously can't, the clock can't be put back to what the situation was on 21st.
the EC says that the split, as I said, that order is not, it says that the split occurred on 21st, the rival faction emerged on 21st.
So it relates back to.
Right. And my lady, that's why I pointed out, even on the 25th and 30th, their side, for whatever reasons, on issues which were emerging or simmering within the political party, were already writing to the Election Commission, recognizing the authority of the Election Commission on 25th and 30th. I'll revisit some of those.
What you are saying is the pot was boiling, it's just that it was
In fact,
ratified by the
as-
Election Commission.
Yes, that's another issue I'll touch when I come to that particular issue. According to us, it was simmering for a while. It culminated in the rival factions ultimately by way of a resolution expressing themselves on the 21st of June, led to the events which happened, and ultimately a petition was filed before the Election Commission around the 18th of July. And even that order recognizes all this that started earlier. I don't have to.
All para 15 does not expressly use the expression split at all.
Right, man. Right.
It doesn't-
I'm very grateful.
Just says which of the factions of the original political party represent the political party. That's the function of the Election Commission. Let's go back to para 15, because one needs to look at what is the relationship between para 15 to the erstwhile para 3.
Yes.
Rival sections.
The marginal note refers to splinter groups. The expression splinter groups is not used in the text of the provision at all.
Yes. Yes.
It says that the text says the rival sections or groups of a recognized political party, each of whom claim to be that party. Para 15 applies in a situation where you have different groups within a party. Each says, I represent the party. I am the Congress. I am the Shivsena. I am the BJP, so on and so forth. None of them have professed to leave the fold of the party.
Right.
So the Election Commission then has the power to determine which of those rival factions represents that party.
Right.
Now, para 3 operated in a very different realm. Para 3 applied in a situation where there is a split within a political party, in which case, provided you had not less than 1/3 of the total membership of the party, that would be deemed to be the original political party for the purpose of the House.
Manoj, may I just
Now-
add to what your lordships are saying?
Right.
They 1/3 leaves. 1/3 leaves under the 10th schedule and says, now treat us as the original political party for purposes of 2-1.
Right.
That other political party continues.
And
The other political party continues from which they split.
so therefore, they're deeming fiction that therefore the 1/3 then is deemed to be the original political party to which the group belongs for the purpose of para 2-1.
And for their purpose.
Right.
For taking any direction as far as they are concerned.
Para 3 has gone. Para 3 has gone.
Right, right.
Now, in a situation where the Election Commission recognizes under para 15 of the symbols order that one particular faction represents the political party, can this at all be within the purview of the 10th schedule then?
According to us, not at all, my lords. According to us, not at all. In all humility, I say so. And my lords, Right.
The acts of the person as a representative of a constituency vis-a-vis that of a person.
My lady,
party.
what happens is when you participate as an elected representative and vote on the floor of the House,
Can you draw a line?
you can't. Anything which comes up on the floor of the House where you exercise your right as an elected representative is saved. The Constitution says so, 189, and your Lordship's judgment says so.
Is saved, but the act per se of doing something which is not contemplated.
So you will lose, you will be disqualified. There is a difference. If ultimately some disqualification petition is allowed, that person will stand disqualified.
So disqualified for acts which were supposed to be done by a person as a member of the party.
So you are disqualified in your status as a member of the House, but your acts done during the pendency of the disqualification petition remain untouched.
No issues on that. But can you go beyond it and say that this qualification, he is, say, not abiding by the whip relating to the internal affairs of the party, would still, the clock would be put back to where it
so
was.
even if
Status
the
quo
so
ante.
if the clock is put back,
Yes.
and he is ultimately held to be, suppose your lordships were to hold against and say that you did not follow the whip, you did not represent the majority of the party, and you have incurred the wrath of Schedule 10, the person concerned will stand disqualified. But to say that the consequence of that is that even before he was disqualified and an order was passed by the speaker, all actions that he participated in, which are as per the settled law by your lordships to say that he's fully entitled to participate in, will stand annulled, is wrong.
So you're saying it can't be sifted, the act done by a person.
Your lordships have time, and the Constitution says so, and your lordships have said that pendency of a disqualification petition is no ground to say that an MLA will not participate, and under various circumstances. It arose in the case of a disqualification petition pending. It happened in the case of resignation letters. It happened in the case of Nabam Rebia to say where a removal was pending of the speaker. They said you can't stop them from participating in the removal of the speaker merely because there is disqualification petition pending against them. And especially in Shivraj Singh Chauhan, Para 78 deals with these situations. You can't say because it was pending, thus it tilted in favor of one party. The court says these are matters which happen at any given timing of any vote for anything, trust or otherwise, someone will benefit or the other. But you can't trace it back to say, had we treated it on that day as disqualified, you would have not been entitled. Thus, any vote that you've given in the trust vote or anywhere else all stands annulled.
So the consequences will flow prospectively.
Yes.
Para 2(1)(a) of the 10th schedule can have no application, right? Because para 15 postulates that the claim is that I represent a political party. And the election commission will then decide which of the factions is representing the political party. So in a situation which is governed by para 15, there is no question of having voluntarily given up membership of the party. Right?
That's what it comes to. In other words, a majority, then again it goes into the question of, but then in the facts of this case, the majority based on the para 15, as it turns out in the assembly, is based only on the legislators. So you have the majority of the legislators to support you in the legislative assembly, and therefore you can appoint the leader of the house, who can only give the whip. So therefore the question of anti-defection would not apply at all.
One, B, our case, absolutely right. And our case in addition is also that the decision which the legislature party took had the political authority also to take that decision. I'm going a step further. It is wrong to say the legislature party elects the leader. The legislature party, as the rule, brings and appoints the whip, conveys it to the speaker, but doesn't mean the political authority is not there. The problem is they tend to segregate the two and say you only had the majority of the legislative party. The EC says when we go through the whole thing, percentage of votes polled and the number of members you have is also a ground to recognize a political party, apart from the membership of the political party.
Mr. Kaul, para 2(1)(b) still poses a little bit of a problem. Forget this case. We're now analyzing it as pure doctrine. As I said, once a para 15 of the symbols order situation arises, para 21A of the 10th schedule can never operate, right? Because once you are deemed to be the political party,
Yes,
no question
absolutely.
of you having given them. Even that faction which is not recognized as the political party, they have not voluntarily given up membership. That's a little complicated. We'll keep that aside. But para 21B still poses a problem because the order of the election commission is prospective because it determines which of the two factions is the political party, right? If the order of the election commission is prospective, then we'll necessarily have to hold that though it does not date back to the defiance of the whip, once this is recognized as the political party, then para 21B will also not operate. Because if once your faction is recognized as the political party, then where is the question of a defiance of the whip? The defiance of the whip is of that political party, right? So
And
willy-nilly, it will impact. It may not be retrospective, the declaration by the election commission, but it will certainly have a retroactive effect in the sense that then there can't be a defiance of a whip, isn't it?
and then the question will arise,
Otherwise, it will be anomalous.
then the question will arise, the speaker will look at which whip and which leader. And I'm sure my learned friend will have his chance to argue. Yeah, I'm sure you will. But all that I'm saying is that we very patiently heard you for 3.5 days. All that I'm respectfully submitting is that what is to be seen, and that is why what is to be seen is those three rules. The members of the Legislative Assembly appoint the leader conveys
That you have made a note.
or designated posts, and the whip, because, and that is why even with para 3 existed, my lord, and at the cost of repetition, I'm just troubling your lordships with it. Rana said, and I'll read those paras, the speaker can't embark on an independent inquiry into the affairs of the political party.
Mr. Skoll, let's do this. Now you've come up to issue number F. You can quickly go through G, F ke baad ye aata hai na? GHIJ. So you can finish the 4 and then go straight to the judgments which we are. And now we need to observe the clock. There's no clock here, right?
Right there, actually.
Well, as we removed it. Well, as all that I'm saying is I'll need some time tomorrow. I don't think I can cover so much. An hour tomorrow. I'll need an hour.
We have to wrap up by tomorrow because we don't want to keep this parted beyond Holi. I mean, we have to finish this.
I'll go as fast as.
They take 2 hours.
Well, it's 3.5 hours plus 2 or 3.5 days plus 2 hours.
Where to wrap up today?
Yes.
And
Your colleagues.
Mr. Jethmalani and Mr. Marinder Singh all.
And STUs.
Malad, I'm trying my best to cover as fast as I can.
All right. So long as your side completes by 2 o'clock tomorrow, we are on schedule. 1 o'clock.
Now 1 o'clock.
In Bombay, we used to rise. Anyway, so we started at 11.
Yes. So, my lords, now next, kindly have what is the scope and power of the speaker to determine the whip and the leader of the House Legislature Party? What is the interplay of the same with respect to the provisions of the 10th schedule?
Yes.
Again, my lords, the submissions which I have already made, this whole presumption that a whip appointed by a legislature wing does not represent the authority of the political party is entirely misconceived. And it is misconceived, as I said, my lords, that you cannot segregate at the cost of repetition. 6A and 6B of the symbols order categorically provides that percentage, number of votes polled, MLAs, MLCs, members of parliament, all are part and integral and organically connected to a political party.
So how do you answer G then?
So my answer to G is that we will go back to the rules again, the Maharashtra Assembly rules. And the question is, What is the scope of the power of the Speaker to determine the whip and the leader of the House Legislature Party? What is the interplay of the same with respect to provisions of the 10th schedule? If under the rules, members are members of the legislature party, they appoint the leader. Naturally, the majority will appoint the person, whoever they do, will prevail over a minority appointing the leaders. Naturally, that would prevail by the simple rule of majority. And that leader in turn will convey the whip. Now, there to say that the speaker will be directly in touch, will determine on his own, that's where Rana comes in. That you're not embarking on some independent inquiry. Your prima facie view is limited to the issue of disqualification. It says you'll take a prima facie view under the 10th schedule. A prima facie view, qua disqualification. But you're not embarking, like the Election Commission, on an independent inquiry into who represents, who's the whip of the party, who's there. The assembly rules provide. And the interface and the interaction of the speaker is with the leader and the whip. And the whip is communicated by the leader. The leader can only be appointed by the members of the House.
Disobedience of the leader of the legislature to the speaker.
In fact, my lords, Rule 5, which I had, Rule 3, subclause 5 of the rules I had shown, specifically says that it's the leader of the legislature party who also informs about the disobedience of the
Rule
whip.
3 we saw.
Yes, Rule 3, subclause 5. Because I'm also now trying to rush through as much as I can.
3, 1 and 5.
My lords, as far as the 10th schedule is concerned, my lords, this may not be directly arising out of this question. But my lord, it's a serious question that you can effectively stifle in a party democracy, as happened here, because the resolution is passed on the 21st. On the 23rd, disqualification notices are given. You know, in the resolution of 21st, where people have said that we are not with this coalition continuing, naturally there is a good chance of a trust vote coming. Look at it the way it's always been said that this is how you'll hamper, harm democracy. The moment you know there is internal dissent, the moment you know you will not within the party be able to survive an overwhelming majority is not with you. The easiest thing is, suppose there are 105 elected members. They know 100 here and the overwhelming cadre of the party are not with them. 5 of them go and file a disqualification petition. And that disqualification petition is not decided by the speaker because there's no timeline, unlike the removal of a speaker where there are timelines under the rules provided for. And he keeps sitting on that. So a trust vote, which ought to happen immediately, and a government which has gone into minority, or a ministry which does not any longer enjoy the confidence of the House, continues because there can be no trust vote. Because what was sought to be argued was that a trust vote can only be when the government is formed and not later. So the abuse of that is enormous. And that is why this was a reason in Nabam Rebia, my lords, when Justice Mishra dealt with that issue. And I keep coming back to say that let's balance the two and see. A speaker can definitely, in such a situation, wait with the disqualification. He should be keen to immediately establish his majority and then take up disqualifications. Because if an MLA misses out on the vote or an MP misses out on the vote to remove the speaker, there is no second chance on that. There's no judicial review of that, but there's a judicial review of disqualification, which can happen. And he specifically dealt with it in para 248. This very issue. Then, my lords, and again, as far as the party is concerned, the Election Commission order is there. There they've already said that there were no even internal routes available for dissent. That we are arguing in the other petition which the petitioners have filed. The Election Commission has said we've gone through the Constitution. How does someone dissent here? How does someone express its dissent in a matter like this? You've left nothing. The same party president is elected by a body, which is the Electoral College, and he appoints the Electoral College, which is there the subject matter. So ultimately, there was no other option left. And that is the totality which the Election Commission took into account, and took into account percentage, MLAs, MPs, votes polled, and then said, we recognize you as the party. Then, my lords, as far as the conduct is concerned, for instance, my lords, in Rajinder Singh Rana, I'm not distinguishing, but I'm giving instances of 21A. I'm giving instances of 21A. There on 27th of August 2003, 13 MLAs from the BSP met the governor asking the governor to invite the leader of the Samajwadi opposition party to form the government. It was actions like these which are regarded as ex facie voluntarily giving up the membership of the party under 21A. Here the only allegation against me is that under 21, on 21st we held a meeting of which I say I never received any notice. They say we sent you a notice, we haven't received any notice. And the other notice at 5 p.m. the same day. And they say you voluntarily given up the membership of your party because you did not attend a meeting. That's the overt act they're talking about, which goes on and is the basis of the first two disqualification petitions. In Ravi Nayak's case, my lords, there were photographs showing the MLAs of the political party with the opposition party. And they approached the government saying that they have no longer support the original political party. These are overt cases of 21A. Where, when my Lord the Chief Justice yesterday put the question, nothing more requires to be done. But your whole basis of the case is you've not attended 2 meetings, out of which I don't receive a notice and of the other. You hold it an emergency meeting the same evening. And it was in that context on 27th when your lordship said, give them more time to reply to this. To which your lordships are coming told that your lordships have toppled the government. It's the judicial order which led to toppling of the government. In G. Vishwanathan's case, 2 members of the AIDMK were expelled. After that, they joined MDMK. When they joined MDMK, a motion for disqualification was moved. So these are acts of leaving a political party, joining another political party, supporting an opposition party to form the government. Here, the same political party continues. The cabinet ministers were cabinet ministers in the old regime as well. The Election Commission has recognized them as the recognized political party. So this whole split, no merger, 10 schedule, where does it come in? Then, my lords, please come to question H. My lords have H.
Yes.
Are intra-party decisions amenable to judicial review? What is the scope of the same? My lords, from Sadiq Ali downwards, your lordships have said that it is the Election Commission. Of course, the Election Commission's order is subject to judicial review within the known parameters. And your lordships have held that under Article 324 and the symbols order, the power to recognize a political party, the power to recognize a rival faction within a political party is the exclusive jurisdiction of the Election Commission, including interim orders, including awarding interim symbols and interim names, which it did in this matter till the dispute was being heard. And it is the only body which has the necessary requisite expertise and wherewithal to go and look at the larger picture of majority. Not the speaker, not the governor.
16A.
Please, my lords.
Section 16A.
Yes, my lords. Next, my lords, is the question I. What is the extent of the discretion and power of the governor to invite a person to form the government, and whether the same is amenable to judicial review? My lords, apart from Pomai, Shivraj, etc., which we've already argued, your lordships in Rameshwar Prasad went to the extent of saying that when a majority is claimed merely because the governor is of the view that the majority has been cobbled by illegal and unethical means.
It's a converse case. That's a converse case.
Yes. So I'm saying
There, that's a resolution of the House by the governor. Because I think, I'm not very sure, I think before a coalition could be formed, the governor dissolves the House. And the plea taken is that if we give more time, there could be horse trading and buying up more legislators to form the government.
absolutely, my lords, but look at the extent to which the Supreme Court goes. It says that, look, a governor is not some autocratic political ombudsman. Those are the words used in Rameshwar Prasad. So
Mr. Prasad, it was Bhuta Singh.
Your lordship knows that only too well.
Firstly, according to us, it's a legitimate resolution passed, representations made to the governor. I'm saying even to the extent where the Supreme Court has said that even if you think in your personal view that something was by unethical means, even then you can't refuse a majority government to be sworn in. That's not for you to decide. But here, there is a resolution which is conveyed. 7 members supporting the government have said so. And to that, my lords, their argument was that your resolution that you talked about, and I want to read that resolution to my lords, talks about the leader being changed and the whip being changed. It doesn't specifically say it's withdrawing support. And even the letter to the governor did not specifically say you were withdrawing support. Now, my lords, with utmost respect, the governor takes note of the resolution. The resolution says the leader, the whip are being changed. There is huge discontent amongst the party with MVA continuing, and we are not happy with this coalition with the MVA continuing. Given this fact, given that 7 other MLAs say that we are withdrawing support, if the words in 121 of Bumai Para 121 saying that the governor will use all processes and means to come to a conclusion, if the governor on the totality of it comes to a conclusion that it's a fit case, and I'm not talking about violence, etc., as your lordship rightly said, let's keep that aside. But surely if the leader of the opposition, 7 MLAs supporting the party, and a resolution of the majority of the MLAs within the party says we are not happy, even if that one word, as they said, was not present, saying that we are withdrawing support, is the governor not within his rights to come to a decision that this is a fit case where a floor test should be proved by the chief minister? It's not a case, my lord, of someone misusing this process. Someone, just one person walks in and says, I don't have any faith. I could understand that it can't be done lightly. But you have 7 members who are part of the government. You have 34 or 55 MLAs giving a resolution that we are not happy with this coalition. Is the decision of the speaker such that your lordships and exercise of your lordships jurisdiction under 32 will interfere with it? Is it so bereft of any application of mind? Or smacks of non-application of mind? Please have that, my lords, that resolution which my lord the Chief Justice also yesterday asked me to read, because the letter I had read out. Please give me that resolution.
Convenience compilation volume 2.
Convenience Compilation Volume 2, PDF, page 55.
Only 50.
My lord, sir, the resolution of 21st of
Yes.
June. Resolution of meeting of Shivsena Maharashtra Legislative Assembly 2019 to 2024. We, the following members of the 14th Maharashtra Legislative Assembly belonging to the Shivsena, we are notified as the members of the Maharashtra Legislative Assembly as members of the Shivsena Legislature Party. We had unanimously elected Mr. Eknath Rao Sambaji Shinde on 31st October 2019 as group leader of Shivsena Legislature Party. There was pre-poll alliance between the Bharatiya Janata Party and Shivsena Party for the 14th Maharashtra Legislative Assembly 2019. There has been great dissatisfaction prevalent amongst the members of our party, that is Shivsena, and our party cadre at large, on account of corruption in the government, administration regarding police posting, corruption by the then Home Minister Anil Deshmukh, who is in jail, and sitting Minority Minister Mr. Nawab Malik, who is also in jail for involvement in underworld Don Dawood Abraham. Apart from the above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds from the opposition. Ideological parties who are now a part of the government were using their office and power to undermine the basis and foundation of our Shivsena cadre. There is enormous discontent amongst the cadre of our party, Shivsena, from forming government with NCP and Indian National Congress, who are ideologically opposed to our party, the Shivsena. There has been a compromise on the principles of our party, Shivsena, which has been a party with fierce ideological base and was formed for fighting for the rights of local Marathi people. For the last 2.5 years, our party and its leadership have compromised party principles by aligning with contrasting ideologies for the sake of achieving power in the state of Maharashtra. The ideology of our party leader, late Balasaheb Thackeray, was to give a clean and honest government to the people of Maharashtra, and also without compromising on the principles of Hinduism, which was defeated by the first day itself by aligning with the opposition ideologies. Shiv Sena had forged a pre-planned alliance for 2019 assembly elections. They sought the blessing of the voters for this Sena BJP alliance, which the voters accepted and voted in favor of this alliance. After the results were out, the Shivsena severed its ties with the BJP and formed an alliance with the opposing parties, which they had fought against the 2019 assembly elections. This act of our party leader had a tremendous negative impact upon the voters and party cadre at large. There was a continuous hue and cry towards the party leadership for the act of aligning with the opposing parties. Ignoring this, the party leadership went ahead and formed a Mahavikas Adi government. For the last 2.5 years, we, the Shivsena Legislative Party members, were facing tremendous pressure from their electorate's voters. We, the members of the Legislative Party, as well as all the leaders and workers throughout the country, were facing a lot of humiliating questions from our voters on account of our support to leader of the opposition. Our leader, Shri Balasaheb Thackeray, was always a strong nationalist. We have also been subjected to a lot of criticism for being a part of this corrupt Maharashtra government. In view of the above, the members of the Maharashtra Shivsena Legislature Party have met today and resolved. It is hereby resolved and reaffirmed that Eknath Rao Sambaji Shinde, who was appointed as the leader of Shivsena Legislature Party, is and continues to be the leader of the Maharashtra Shivsena Legislature Party. 2. It is hereby further resolved that Mr. Bharat Gogable be elected and appointed as Chief Whip of the 14th Maharashtra Shivsena Legislative Party. Appointment of Mr. Sunil Prabhu is cancelled with immediate effect. Now, my lords, two things emerge from this. One, it is not a reference to the legislature party. It is a reference to the political party and the disquiet amongst the political party. The only ground taken is that your specific letter to the governor did not specifically, or the resolution specifically mention that you've withdrawn or you will be withdrawing support to this government. Now, if the essence of this resolution and the letter written is we have no faith in this coalition government, and independent MLAs are writing to say that we have no faith, they have lost the confidence, is the decision of the governor who has seized of this resolution, who has told that the MLAs have no faith in the coalition government. 7 independent MLAs who are part of the government, were 2 being ministers, writing the same thing, and also the leader of the opposition. It's not, my lord, that the leader of the opposition, what he writes cannot be taken into account. He takes all this into account and comes to a conclusion. The impression is given to your lordships as if the governor has acted without any application of mind or any material on record. This is, according to me, my lords, more than sufficient material in all humility, because at the end of the day, if the principal concern of the governor is majority on the floor of the House, what better indicator of a majority on the floor of the House than MLAs in substantial numbers writing to them to say that we do not support and we have no faith in this coalition government. And it is this with the Yadurappa judgment dealt with. There, in fact, they went a step further. There they said we have no faith in the chief minister of their own political party. Whereas in Yadurappa's matter, there were MLAs of the BJP writing to the governor to say we have no faith in Mr. Yadurappa continuing in that government, and there should be some other person from the party who should lead. And the Supreme Court said they have not said they are forming another political party. They have not said we are supporting another political party. This is not a case to attract 2-1A. Then, my lords, is the next question,
All over.
which is J. what is the scope of the powers of the Election Commission of India with respect to determination of a split within a party?
This is on para 15 of the sim. J will arise in the other matter which pertains to the election symbols order.
But yes, but now that it's there, may I just take two minutes of your-
Let's, if we don't want
It is
to go
pending,
that
why
way,
should-
it's
Yes,
pending.
the only thing, my lords, that I wanted to say was that right from Sadiq Ali downwards, it is settled that the Election Commission has the exclusive jurisdiction to decide the issue, and the correctness of Sadiq Ali has not been questioned. The correctness of Sadiq Ali is nowhere questioned.
That you reserve your energy for.
Very well. But my lords, one factual thing that I wanted to point out, as far as the governor is concerned, on 21st itself, that resolution was sent to the governor. On 21st itself of June, it was sent to the governor. On 25th, a letter was written to the governor of June saying that our lives are under threat. And even in that letter, my lords, which is at Convenience Compilation Volume 2, PDF page 287, para 2 says, as is common knowledge, we no longer want to be part of the corrupt government of MBA government. All I'm saying is, my lords, other than the resolution on the 25th, when we asked for security also, we again reiterate that we do not want to be part of the government. So to say that we never communicated this to the government is to the governor is factually incorrect. Now, my lords,
Mr. Cole, just for our information, there are 34 signatures on this document resolution. Are any of these 34 members of ministers in the House?
yes,
How many?
at that time or now?
When this was signed, 21st?
How many were out of 34? How many were ministers on 8?
Only one thing,
Eight.
which
Eight out As your Lordship said, I'm not then addressing your Lordship on the last question on the Election Commission issue.
Yes, I think we
I
can.
will not, but he's
Anyway, that's a law from Sadiq Ali. There's jurisdiction of the EC to.
Not only that, very interestingly, just note, convenience compilation 1, PDF page 82. Ground D of Mr. Subhash Desai's own writ petition 493 of 2022. He says, can I just read that line? Ground D. Because the constitution of a political party under the 10th schedule and the action of the governor legitimizes what is expressly prohibited by the constitution, the governor has sought to recognize what the constitution prohibits. The governor is also not empowered under the law to recognize who is the Shivsena. That is the domain of the Election Commission. Admittedly, recognition of Shivsena and its leadership has been endorsed by the Election Commission, and there is no dispute whatsoever to a challenge before the appropriate authority. Now, if that is the domain of the Election Commission, and when a petition is moved that there is a rival faction, which is the party within para 15, and the Election Commission now takes a decision on it, and your lordships were addressed for 4 hours on that day to say that Election Commission should not proceed with it, because your lordships are seized of this matter before a constitution bench. Till your lordships dismissed that stay application moved by them. And they said the Election Commission should not go on with them with the same convoluted argument, status quo ante, relates back to the day they were disqualified, thus everything else suffers from the sin of unconstitutionality, and thus the Election Commission should not proceed because any petition before the Election Commission would be tainted by what these MLAs have done.
As a matter of propriety, should the governor have invited Mr. Shinde to form the government?
Manoj, may I with respect say that if a chief minister resigns and a combination emerges in the matter, what is wrong with it? This was a pre-poll alliance also. In fact, the change which came about later was with a party they had opposed all their lives. And this was a pre-poll alliance. If the governor at that stage feels that this combination can form the government, you can't have a headless state of affairs, you can't have no one there. And he asked them to face the floor test. It's not as if the governor after that gave them 20 days. Your lordships are very often even frowned upon that. When a long leeway is given to form governments. He immediately said in a day form prove your majority. Speaker the next day, the government the day after. So my lords, when we are testing the action of the governor, there could be two views. By hindsight, people may be wiser on some issues. But as I respectfully submitted, is this a case? Merely because the petitioner feels the only way out was a vote of no confidence, which law says so, my lords? From Bomai downwards, the lordships have said floor test is the best way to do it. What was the need for him to ask for the leader of the opposition to move a vote of no confidence? Why could he have not asked the existing chief minister to face a floor test? And why was the chief minister so scared of facing a floor test that he resigned within 10 minutes of the order being passed? Because he knew he did not have the majority. Now, if you can't leave aside your party, that's why I said, my lords, you exclude all those MLAs. You still don't have the majority on the floor of the House. Can such a chief minister have any moral or political authority to continue after that? And today wants all these actions to be annulled. From governor calling a government, floor test, everything to be annulled and status quo ante to be restored. You refuse to face the floor. Firstly, my lords, I respectfully submit, these 39 MLAs cannot be excluded. Because the day on 27th when the interim order was passed here, firstly, of course, we said it was not based on NABAM, but even I take it was based on NABAM. What was wrong on it, my lords? That was the stated constitutional position it held the judicial field. It till date holds the judicial field. If a bench of this honorable court relies on a constitution bench decision which says that a speaker whose own removal is pending cannot proceed with disqualification, what is wrong with it? If they had recorded that, it was an absolutely valid order. They are questioning now in a reference, but it is still it has held the judicial field. It's the accepted position today of 5 judges of this honorable court. Till your lordships comes to a conclusion that it doesn't lay down the correct law, if at all. So even if the 27/6/2022 decision was based on NAVAM, it was only on principles of natural justice. Suppose it was
Another way
based
of
on NAVAM.
looking at it also. There's another way of looking at it. Suppose the interim order was not passed on the 27th, which according to them effectively had the consequence of staying the action by the speaker to disqualify these people. and take it at its worst that therefore the speaker would have disqualified these persons. If the speaker had disqualified these persons, they would have ceased to be members of the House. They would individually stand disqualified. Would the governor have still been justified in calling for a trust vote?
Yes.
Because he would have then said that 39 members, 16 plus 22, 39 members have been disqualified from out of the ruling three-party coalition. I still want to have a trust vote. Would he have been justified in doing that? If we say in the affirmative, then you have an answer really of how the voting has taken place,
Right.
excluding these people.
But my lords, 2(1)A, which they rely on, there is no case of 2(1)A made out. Apart from everything else,
No,
because
but
I do not
also-
attend two
yeah,
meetings.
That's a separate issue, but on the point as to whether this court's order.
Yes,
has
yes,
been-
my lords, I bow down. My lords are absolutely
Assume for a moment that
Yes.
this court had not passed the order, what would have been the consequence at the highest? The speaker would have disqualified these people,
yes,
right?
Yes, yes.
If they had been disqualified, then they would have gone out. The speaker would have, the governor would have then called for a trust vote. With the one change that Shinde would have not been called upon to be the chief minister then. Then the governor would have called upon perhaps
And my lords, you take it forward. There are
the BJP to form the.
there are too many
Really constant.
hypothetical assumptions,
Which is what
presumptions
was
on
one
the
of their
petitioner's
arguments.
part. So and so would have happened. Thus, this would have happened. Then there's a constitutional saying everything would have been annulled in the process. That's not how.
They are right in to this extent that the request to Shinde to become and to swear in Shinde as a chief minister and the opportunity given to him to establish his majority on the floor of the House on the 30th came into being only because in the meantime the speaker could not disqualify Shinde, because if he had disqualified him, all the 39 would have gone out. It would have not made a difference. The Shivsena, probably that coalition wouldn't have come back to power. Possibly, because these 39 go out. But with the 39 going out, the composition of the government today would have been entirely
My
different.
lords, as I respectfully submitted, these are
Hypothetical.
too many hypotheticals. But all I'm saying is the speaker could not continue with the
Not
disqualification.
exactly hypotheticals, because you know what was happening and what would have happened.
No, my lords, what I'm saying is that
So the speaker was acting in post haste. That's why, the writ petition.
the speaker was acting in post haste in every which way. On the same day he approves a new leader. On the same day he says you file your replies within 2 days.
Of course, the 39 would have come to this court and said, well, we have been disqualified without giving us even 7 days
And my
notice.
lords, that's why I
In which case, stay the order of disqualification, which is contrary to law.
wanted
That is
to
a
point out
different scheme then.
one timeline which is important, which
No,
I
no, which way
forgot
it
when
was
I was
gone.
reading the timeline, and it has some relevance here. On 21st, when the notice to the deputy speaker was sent for removal, on 21st, was sent to the speaker, it was signed by 34 MLAs and it is admitted by the
Deputy Speaker.
deputy speaker in his Actually, the chart I gave, quite apart from removing the 39 or whatever the 3 independents, they were actually running away from actuals. 13 of the people who were supporting them also abstained. 16 abstentions were there. 13 of them were their own people who were supporting them abstained.
Came to 99.
That is how they came to 99 on that day.
What are you saying? Sorry.
Please, my lords.
You're saying something?
Well, it's the second page, where if your lordships were to see the first chart, votes against Mr. Eknath Shinde, 19. This is a 99. These are, my lords, the 13 people of the 16 who abstained. 24 abstained, 13. 13 were from Agadi, the NCP.
Of the 24 who abstained,
Yes.
13 of the other group.
Yes. So quite apart from the 42 being deleted, your own people were not there to support your government. Yes. That is why this number comes to 99.
13 from MBA abstained.
Abstain. So you leave aside disqualification. I have even given charts that if you exclude the disqualified members, still we win. But here are people who are supporting you. Even they abstained. Because you had lost the support. Yes. Yes.
29 is Shinde and 16 is.
I see. I got it, yes.
Now, my lords, just to answer what my lords put to me, my lord, the Chief Justice, to say that Mr. Shinde would not have made it is wrong for the simple reason, my lords, and I say this humility, that A, till he is disqualified, he continues to be a member of the House.
No. What the Honorable Chief Justice says is, like, if he would have been
Yeah, but my lords,
disqualified, then in
my
that
lord, but
situation-
as I respectfully
so he was
submitted,
one of the person against whom the disqualification.
but the speaker could not have gone ahead with that disqualification in view of Nabam Rebia. So how do we presume had he been disqualified, then had he been then all?
Not pressed at all.
Yes, my lord,
Only argued according to you.
but my lords, I said so. I said so, and I've been right through saying from the beginning because I argued. I'm not for a minute suggesting I did not argue Nabam Rebia. I did argue Nabam Rebia.
No, but even if you look at it from on a demerrer,
Yes.
that suppose Nabam was not there, the consequence of Nabam not holding the field would be that the speaker would be entitled to decide the disqualification, notwithstanding the pendency of a notice for his own removal.
Right.
If he had decided the disqualification,
Right.
then these 39 would have gone out.
Right.
In which case, still the government had to fall.
Absolutely.
On the numbers that
That's why I've given the charts with 42. I consciously made these charts with 42, minus 42, and now I'm going a step further. Mr. Jethmalani rightly pointed out to me, he said that these 13 also, the ones who were supporting them abstained. There were 16 abstentions. So whichever way we look, the numbers were not there. And that's why this chief minister, the then chief minister, resigned within 10 minutes because he knew he did not have the majority. And he was not confident to face the floor.
Because he was aware that
He was aware what was happening. So everything we go back to say that because of disqualification, this was fait accompli. You can't even take care of people who were supporting you, the 13.
Mr. Call, you can consider from this angle also. So far as Nabam Rebia is correct, the order dated 27/6. You might have pressed Nabam Rebia. At that time, you might have argued also. And you, according to you, argued also. But this court, correct, did not injunct speaker, correct? Maybe technically till 12th, correct? He was restrained from, it can be said he was restrained. But there was no restraint at all, correct? Against the speaker exercising the powers.
I bow down to it.
If the Nabam Rebia would have been considered by this court, then there would
Then
have
he
been
could not have continued.
Then it would.
Then no proceeding should have been stayed before him. My lords, I said so repeatedly, the entire argument was heard. Ultimately, the court, considering because the same argument made, there are problems, Nabam Rabia applies, doesn't apply. The court said only on pure principles of natural justice, give them more time because the rules provide for 7 days. And on a weekend, you've given them 2 days.
16, not the
So there was say that your lordship's order was the result. And then your lordships are told because of that, rewind everything.
On a lighter side, everything went so fast.
Well, that is
No,
politics.
no, we are not. That is why it is.
In fact, my lords, that's why in para 78, your lordships say of Shivraj Singh Chauhan, timing on a particular date, what happens, in whose favor, what tilts, that's politics. And they say that's none of the concern of the court. The court, that's what your lordships records in para 78 of Shivraj Singh Chauhan.
You want to show some.
Yes, fine. I'm not bothering your lordships with this, but another argument which was made was that even in our notice to the speaker, we had not mentioned anything about majority. There's a specific paragraph in the letter to the deputy speaker that he has lost the majority. So to say that we had not mentioned it is factually incorrect. And as far as notice to the speaker is concerned, my lord, that's the last point before I go to the case law. 21st, I give a notice. The deputy speaker files an affidavit in this court that that notice was received. Secondly, on 22nd of June, a hand-delivered copy is given. On 24th of June, an email is sent to which apparently the speaker comes, and that day Dr. Dhawan appeared. He appeared in court and said that to this, it was not from an authorized email. So we pointed out that there is Rule 18 of the Maharashtra Legislative Assembly rules, which just talks about a signed notice being given. There's no other restriction on it. So even if we exclude the 24th, 21st, we send the deputy speaker accepts that such a notice was given. 22nd, a hand-delivered copy is given with a stamp, which we showed to the court when we went. So we said, what are you talking about not receiving a copy? This is a hand-delivered with a stamp. And on 23rd is the disqualification petition. And that is why, my lords, I said the scope for misuse of disqualification is enormous. And that is exactly what was sought to be done. You knew there was discontent. You knew it was simmering. You knew it reached its culmination on 21st with a resolution being passed at the meeting that overwhelmingly the cadres were not happy with this coalition, and you knew that the next sequitur to this will be a trust vote. You immediately move a disqualification petition, and the speaker on the very same day accepts your person, and then 2 days later I'm told file a reply. It's under those circumstances that I came, because repeatedly your lordships are told constitutional propriety, morality, abuse. If at all there has been abuse in this matter, my lords, it has been by the regime then in power and the then deputy speaker, with the hurry that they moved, that they did not even follow the basic norms of natural justice. If the 7 days were required, what was the hurry in giving 2 days? And the only argument the other side had was that in one of the matters your lordships have held that even 2 days was enough. So I'll also cite 5 judgments to say that 2 days were not enough. Where your lordships have said there's no straitjacket formula, it has to be seen in the facts of every case. That takes us nowhere. But given the facts, what was this great hurry that over a weekend you wanted replies to be filed? That's what led to our 32 being filed. Quite apart from the fact that Quixote was not a bar to us, because Quixote works if you're seized of a matter, speaker is seized of the matter, you don't go to court. Not in a case where Nabam applies, that the speaker has a disqualification pending against him, removal pending against him, and he cannot proceed at all. It was in those circumstances that I came by way of a 32. Now, my lords, I'll come to the case law.
Case law on the point.
Yes, my lords. Yeah, look. नहीं यार अभी नहीं रुक जाओ कुछ नहीं कुछ नहीं देना. My lords, I'll start by distinguishing Mayawati's judgment.
Why don't you do this? You can actually cite the judgments in chronological order and then distinguish whatever they have cited along the way, so that perhaps you can do that in a chronological order. Whichever judgments you are citing, you can cite them chronologically. And then if they have relied on a particular judgment, you can distinguish it along the way. That's one way of doing it. Or you can cite Mayawati.
I thought, my lord, there are 4 or 5 crucial judgments
right,
that
fair
they
enough.
relied on for their
Fair
case.
enough. All right,
And then
fair
I'll
enough.
come to my
All right,
own.
fair enough. And then you can cite your judgment.
Yes.
Mayawati is that, where is it?
Convenience compilation, volume, judgment compilation, volume 2.
My lords, in fact, if your lordships permit, I'll just very briefly tell your lordships of the facts. I won't bother your lordships with the paras at all. I'll give the facts. I've
Right. but
summed up the
just,
facts.
Just give us the give
Yes,
us the
yes,
reference
yes.
in the compilation. That's all. So if you have to,
Convenience compilation, volume 2,
080.
PDF page 1080.
Citation.
1998.
1998, volume 7, SCC 517. My lords, in 1996, my lords, in the general elections to the UP Legislative Assembly, no political party obtained an absolute majority case. So there was an agreement between the Bharatiya Janata Party and the Bahujan Samaj Party. BSP at that stage had 67 MLAs and the BJP had 175 members in its fold. On 21/9/1997, Mr. Kalyan Singh of the BJP was sworn in as the chief minister. On 19/10/1997, the appellant, that is Avati, announced withdrawal of participation and support of the BSP to the coalition government. All the BSP members resigned from the government. Immediately, the governor of the state convened a special session of the assembly at 11 a.m. on 21/10/97, that date is important, and told Mr. Kalyan Singh to prove his majority on the floor of the house. After that, on 28/10/97, appellant issued a whip directing all BSP MLAs to remain present in the house throughout the proceedings on the next date and vote against the motion. That was the whip issued. On 21/10/97, 222 members of the assembly voted in favor of the government. There was no vote opposing it. On 24/10/97, 13 petitions were filed seeking disqualification of those members of the BSP of violating the whip given on 20/10/97, the whip which had been given. And the petitions invoked only clause 2(1)(b) of the 10th schedule. Your lordships may note that the allegation was 2(1)(b) of the Constitution. On 25/11/97, the concerned MLAs against whom disqualification petitions had been filed their written statements and pleaded that a split took place between the members of the BSP on 21/10/97, and more than 1/3 legislators of the BSP got separated, and thus they relied on the protection of para 3 of the 10th schedule. The speaker on 23/3/98 dismissed the disqualification petitions and recognized the MLAs as a separate political party. In this background is what the appellant said, and in this background what the appellant said is that that it is the whip which is issued by the erstwhile legislature party of the BSP and not the new political party which had been formed. As used in para 2(1)(d) is the legislature party of the original political party of those MLAs is what is to be read into 2(1)(b). The court said nothing doing. Political party as mentioned there in 2(1)(b) cannot be read as a legislature party. So this was a split, a new party had been formed, and they were bound by the directions of the new party and protected by that.
What were they relying upon in Mayawati in particular? What is the...
That a whip of the legislature party of the BSP of which they were a member before splitting
That is
had told them not to vote.
28th October whip.
Yes, had told them not to vote in favor of the motion.
Right.
So they said you violated the whip of the legislature party. And because you violated the whip of the legislature party, you are disqualified. They said we have split and we formed a new party. And our new original political party told us what to do. We did it in compliance with that. So Ms. Mayawati argued that you read legislature party into 2(1)(b) and that whip ought to be obeyed of the old party. The court said, no, we will read it as the political party and they are protected by para 3 of the 10th schedule. Now, my lords, in our case, A, there is no rival faction which has split. The rival faction is within the party. No new political party has been formed. The question is not of an erstwhile legislature party of a party that you belong to vis-a-vis the new original political party that you formed. The judgment at no point says that when a whip is whom the speaker interacts with, the whip as appointed as per the rules conveyed by the leader, etc., should be ignored and we should look at some deeper other whip which the political party is appointed. That's not what it says. All it says is, in the given facts and circumstances, that that legislature whip of the party is not applicable because they are protected by the sanction as given. By the formation of the new political party. So Mayawati, according to us, my lords, has no application at all. And in any case, my lords, as I have said, it's never been our case that it's only the legislature party and not the political party. We've right through said both are co-joined, organic, integrated, and any action of the legislature party has the political authority of the political party to say what it says. Now, my lords, Rajinder Rana, Volume 1, PDF page 834.
(834).
Yes. So, my lords, Rana is relied on by them. I relied for a different purpose. They rely on Rana for two essential purposes. One is that it said disqualification is ex post facto. So everything goes back to the date of disqualification. And secondly, your lordships, in an appropriate case, decided the issue of disqualification as a court of first instance rather than remanding the matter or letting the speaker decide. Those are the two grounds taken to rely on Rana. Now, my lords, just some facts. Quite apart from the second issue, my lords, the straight answer would be the matter was pending for 3 years in the High Court. The High Court then remanded it back. The Supreme Court said the assembly elections are at the end of the year. Rather than remanded, decide the matter. Those are peculiar facts, not that in every case you bypass the constitutional authority and come to the Supreme Court as a court of first instance. But on the first part, my lords, some crucial facts. After the 2002 UP elections, my lords, to the UP State Assembly, a coalition government was formed headed by the Bahujan Samaj Party. In 2003, my lords, the cabinet recommended dissolution of the assembly. And now this is important. Before the resignation of the cabinet, my lords, on 27/8/2003, 13 MLAs of the BSP party met the governor and requested him to invite the leader of the Samajwadi Party to form the government. the opposition to form the government. The governor acceded to the request. And thereafter, Mr. Swami Prasad Maurya, who was with the BSP, filed a disqualification petition saying that they had voluntarily given up the membership of the party by supporting Samajwadi Party and going to the governor. On 6/9/2003, 13 members, those 13 MLAs who had gone to the governor with the Samajwadi Party MLAs, fortified by another 24 MLAs, requested the speaker to recognize a split in the party, and the speaker recognized the split in the party. The Supreme Court said that split and to be entitled to the benefits and protection of para 3 of the 10th schedule is an event which happened later. The governor is only concerned with the day when those 13 BSP MLAs met the governor and requested him to invite the leader of the Samajwadi Party to form the government. And the speaker should have only looked at the facts on that day and said not at subsequent events, and in that context said, ex post facto, it will go back to the day they were disqualified or incurred disqualification under the 10th schedule. It could have never been the intent of the court, and it did not say so, that on one hand, the Supreme Court says that till disqualifications petitions are pending, you participate in all proceedings. On the other hand, the moment you're disqualified, all your actions are annulled. So ex post facto was specific because the speaker started looking at subsequent events. The speaker started looking at a split which had not happened on that day. And they said this is an overt 2-1A act, where you go to the governor, request him to get the Samajwadi Party to form the government. It was in that context. The other part of Rajendra Rana, I pointed out to my lords that, now my lords, another judgment.
Sir, Paul, why don't you do this tomorrow morning? Just give us in 2 pages a small note on how you distinguish each of those judgments.
Very well, very well, very well, very well, very well.
Isn't it?
No, I'll do that.
Just say-
I'll get for all those 4 or 5 judgments
That's
a
right.
distinguishing note tomorrow.
Just 2 or 3 pages.
Yes.
There's a bullet.
And what I'll do, my lords, tomorrow is I have also prepared a written note of the various propositions and judgments that I'm relying on.
Right.
I'm in the process. I'll take your lordships through that. And wherever your lordships wants me to really read any particular paragraph, I can do that.
All right. That will be much quicker then. Yes.
If
Faster.
just
Now,
to,
just so that you know, how long would you take? Will you finish in about an hour or so tomorrow?
yes,
So we target starting by 11 o'clock tomorrow. So 12 if you finish, then between Mr. Jethlani,
What I'm respectfully submitting is.
if you can, Mr. Jethlani and Mr. Maninder Singh, if you can give us a brief note of a page or so.
I was about to say that, Malad, to remain within the time discipline, Malad, we'll furnish a note by today evening. And Malad, very 10-15 minutes, Malad, we'll just make your lot.
If both of you can just give us, email the note to the courtmaster, so he'll circulate it in the night to us and give it to Mr. Sibal, because Mr. Sibal will also be then.
Try to finish before.
And you can also email
The
your note to
problem
Mr.
is the
Sibal.
Solicitor General is to argue. Please remember that.
Yes, of course.
So-
Now, what about the solicitor? So maybe, Mr. Kaul, is it possible for you to sort of complete by say 11:45? Say we start at 11 because we have mentioning. If you can try and compress it by 11:45.
Try my
Then between Mr. Jethlani and Mr. Maninder Singh by 12:15, that leaves 45 minutes to the Solicitor General. If we can do that, we entirely with.
We'll try our best, as succinct as we possibly can be, we'll try.
Because otherwise
that-
it will be
Right.
difficult.
my lords, otherwise the rejoinder could
difficult
be
for us.
restricted to 1 hour. They've argued for 3.5
Otherwise
hours,
it
my
will be
lords.
difficult. If they don't finish by 1 o'clock.
Agenda only depends upon how the other side is.
Then
acting.
one and-
What other side is-
So how long was the solicitor likely to take? Any idea?
He said 1 to 1.5 hours to me. 1 to 1.5 hours to me, he told. He told that.
All right, try and make your arguments as compared. But we'll wrap up with this side by lunch so that, yes.
The first we'll sit down.
No, it's
Within
not
the
like that.
time-
We just,
The one
because,
thing-
only because we are heading
the
towards
one
a
thing-
week-long break, and we don't want to keep this beyond the break. That's the
The one thing the learned Chief Justice is he never gets tired of anybody. He never shows it at least.
That's the theory of it.
No, but that's a fact in my mind as well, because,
I know.
if you have an understanding about how vast the field of knowledge is, you can never tire of
That's
the
true.
arguments
That is
which
true.
lawyers were before.
We've
Because the
noticed
last word is never said until the last word is over.
That's correct. That's correct. And I hope we have.
Very
the last
grateful,
word.
man. Very grateful.